Hello everyone, this is Dr.P.Syamala from the Department of MBA IB, Acharya Nagarjuna University. Coming to our today's topic, it is regarding the prospectus of a company. In previous classes, we have learned about what is a company, what are the types of company, and what are the documents that have to be submitted by the company with ROC. So in those important documents like Memorandum of Association, Articles of Association and Prospectus, we have completed about MOA, which is nothing but Memorandum of Association, Articles of Association. Now coming to the third aspect, which is known as another important document that a company is required to register with the or else to submit with the ROC, that is Registrar of Company. So today we are going to learn about prospectus. And one of the major reasons why businesses choose the company type of or else the form of a business is because it allows greater accessibility to funds. Means a public company that has been incorporated under the Companies Act 2013 is allowed to raise investments from the general public through different modes. Whereas if we see in private company, the company law doesn't allow the private limited company to go for public issue. As we all know that there are different types of companies like public limited company, private limited company and one-person company, which is known as OPC. For these public limited company, many people choose to go for public company. Why? Because if we are having a public company means Companies Act allows to raise investment from general public through public issue like shares, debentures, likewise. Okay, so here one of the major reasons why businesses choose that type of business, form of business, is the reason of greater accessibility to funds. So since a company raises funds from the public, it also becomes necessary that such a company be accountable to the public. Accordingly, to secure the interest of the investors in the company, the Companies Act 2013 mandates the filing of a prospectus with the registrar prior to raising funds. Okay, and moreover, prospectus, if we want to say what is a prospectus, what does it contains, or else what are the contents of the prospectus means, basically prospectus means, if we want to say, it is an invitation to the public. Okay, so the basic content of a prospectus means invitation to the public to subscribe. Okay, so to subscribe the securities, invitation, or else circular, or else notice, or else advertisement. Okay, anyone notice, okay, notice, circle or advertisement. Okay, anything can be considered as an invitation to the public to subscribe their securities, which is nothing but the shares and debentures of a public limited company. Here again and again we have to remember that private limited company is not allowed for the public share, issuing of public share. Okay, so that is why only the public limited company, which are listed companies, okay, they are allowed to go for public issuing of public general public. Okay, so a prospectus is a document issued by a company, public limited company, to invite deposits or subscriptions, okay, from the public by way of issuing securities of the company. They issue the securities, shares or debentures to public. Public will purchase these shares and debentures, okay, and in return they will get the dividends. Okay, so company will get the capital amount from the public. Okay, see here, company and public. Okay, so by issuing the securities to public, shares and debentures to public, company in return gets the capital amount. Okay, and what do these public get means? Public gets the dividends. Okay, profits will be distributed to the public in the form of dividends. So A prospectus is a legal document that a company issues to potential investors, providing them with information about the company's business. What does it contain? What does a prospectus contains? Means prospectus contains a full information regarding the company's business, detailed information of the company's business, like the financial condition, management, and securities. Okay, so securities are nothing but the shares and debentures of a company. So the purpose of the prospectus is to assist the potential investor. Okay, purpose. What is the purpose? Okay, what is prospectus? Means prospectus contains full detailed information about the company's performance, financial condition, management, and securities, everything. Okay, how many directors are there, what is the name, address of the directors, okay, their signatories, each and everything will be in this prospectus. And what is the main purpose of this prospectus? Why the Companies Act insist the companies to submit this prospectus? Means prospectus assist investors. Why? Because this public is investing their amount in the company. Okay, so first of all, before we are investing in any company, we have to know the full information of that particular company, that is it in a good position or not, is it in a profitable condition or not. Okay, then only an investor may show interest in that particular company to invest. Okay, and if at all there is a prospectus regarding the financial aspect, regarding the management of the company, regarding the securities, assets, liabilities, each and everything, then this investor will informed with the detailed information, and this investor will take decision about whether to invest in the company or not to invest in the company by seeing this prospectus. Okay, so prospectus plays very important role, and it is very important, prospectus. So according to section 2 subsection 70 of Companies Act, it defines prospectus as a prospectus means any document described or issued as a prospectus and includes a red herring prospectus referred to in section 32 or shelf prospectus referred to in section 31, or any notice, circular, advertisement, or other documents inviting offers from the public for the subscription or purchase of any securities of body corporate. Okay, so this is the definition given by the Companies Law Act according to section 2 subsection 70. Okay, so if we see here, prospectus, any document, any thing issued to public which includes red herring prospectus as well as shelf prospectus. So in the next slide we will know about in depth about the red herring prospectus and shelf prospectus, which are nothing but the types of prospectus. Okay, so these all are also included in this prospectus. Okay, those provisions also comes under this prospectus. And as I said before, notice, okay, circular, advertisement, or other document inviting the public for subscription or purchase of any securities of the company. So this is the definition given by the Companies Act 2013. So if we see finally, what does a prospectus means? When a public company is collecting capital by issuing shares to the public, has to issue a document called prospectus. Prospectus is a document which contains information about the company. It invites investors to buy the securities offered by the company, and the prospectus must contain true and factual information as investors decide to invest. Okay, so if we see golden rule by Kindersley. Okay, so what is the golden rule? What does it mean? So golden rule of the prospectus was proposed by Kindersley. Okay, in a case. Okay, so in that case he held the judgment that prospectus is one of the means by which the investor is informed about the soundness of the company. Soundness of the company's venture is nothing but is the company is performing good in its financial status, in its management, in its securities, in each and everything. All the information in a positive manner is known as the soundness of the company's venture. Okay, so the essence of the rule, what does the rule says means it is mandatory on part of the company to issue a prospectus. This is the judgment given in this case by V.C. Kendersley. Okay, means golden rule is mandatory on part of the company to issue a prospectus. It is compulsory to issue the prospectus by the company. So it is only required accurate information should be given, not approximate information. Accurate information should be given and with facts. Okay, so this is the golden rule regarding this. Okay, prospectus. And if we see, prospectus means according to Companies Act 2 subsection 70, and we can see here we have three types of private limited, public limited, and OPC, one person company. But here we will consider only public limited company, because private limited company has no right to go for public issue. So therefore only public limited company has been taken into consideration. And here if we see under public limited company goes for fundraising. After fundraising, through it invites public, okay, through a document called as prospectus, okay, in the form of invitation. Okay, invitation. And if we see here, it is important to notice that every time when a company has to raise an investment, why? Because whenever it is going for public issue, definitely at that time prospectus has to be submitted with the registrar of companies. Okay, and whenever every time a company has to raise an investment from the public, so it is the duty of the company to inform the public about its financial position and the purpose of the investment. Every time whenever it is going for example, this year it went for public issue, so at that time it has to submit its prospectus to the ROC, and next year also it went for public subscription, so next year also it has to issue prospectus to the ROC. Okay, so it is the duty, it is the obligation of the company to whenever it is going to raise the investment through the public, okay, it is the duty of the company to inform the public about its financial position and the purpose of the investment. Okay, so a prospectus is the first document through which a company publicizes or discloses its financial and other relevant information, right? So if we see what are the types of prospectus, okay, we have different types of prospectus, like a red herring prospectus, okay, abridged prospectus, shelf prospectus, okay, deemed prospectus. These are all different types of prospectus under prospectus. So if we see the red herring prospectus, though most of us imagine big companies when talking about investments and funding, mid-size and small companies also require investments and they also make public offers. Okay, so not only the big major companies but also mid-size companies and also the small companies, they will also be in requirement for investments, so they also go for public offers. So to safeguard their rights and enable them to have better access to finance, the law provides for red herring prospectus. Okay, so in order to safeguard these small companies and mid-sized companies, okay, to safeguard their rights and enable them to have better access to finance, because small companies and mid-sized companies, it is not easy to get finance. So therefore the law provides them for red herring prospectus, which is nothing but prospectus wherein information regarding either the quantity, okay, either the quantity or either the price, of securities is not disclosed by the company. Okay, rather the company only provides a price brand. This enables a company to gauge the worth of its securities and enables them to achieve the requisite minimum subscription, which may not otherwise be possible had they already supplied the entire information. Okay, so what we need to know is red herring prospectus means it is mainly in concern with mid-size and small companies in order to safeguard their interest. Why? Because they cannot pull up more finance. Okay, so for that purpose, company gave some enable them to have better access, okay, to finance by not revealing about the quantum and price. Quantum is nothing but the quantity, and price, as we all know, price is about the price of a share. Okay, so quantity means how many shares are going to issue. Okay, that is known as quantity, because this is not how many shares, okay, how many shares are the company is going to issue, it is not revealed. And what is the price of the share, it is also not revealed in the prospectus. Okay, so quantum, price is not mentioned to safeguard the mid-size and small companies by company law. Okay, so to those companies this provision is there, and that is known as red herring prospectus. Actually, whenever submitting the prospectus, company need to file each and everything, how many shares are going to be issued, what is the price of the share, each and everything. But in this case, red herring prospectus is given a provision for this small mid-size companies. Okay, so and if we see, a red herring prospectus is subjected to same regulations as prospectus. Okay, like other companies submitted prospectus, no? So what else they are submitted, those regulations also apply to these red herring prospectus companies also. So it has to be filed before ROC at least 3 days before the issue. Okay, at least 3 days before the issue, means before they are going for public issue, before 3 days. Okay, before 3 days of this public issue, they have to submit their prospectus with ROC. Further, the company must file the complete details of the issue with the registrar and the SEBI after the securities has been duly subscribed to. Okay, before they are not they have not given the quantum and price, but after subscription, okay, they have to give another prospectus. Okay, they must file the complete details of the issue, how many they have issued, what is the price of the share. Okay, they have to be filed with registrar and also the SEBI, because these both are two regulatory bodies of this company. Okay, so according to the SEBI regulations, they have to follow. Okay, so this is about the red herring prospectus. And if we see abridged prospectus, okay, what can we say, what does it mean? Abridged prospectus means, we all know that prospectus means it contains nearly 300 to 500 pages. Okay, so nearly 300 to 500 pages, okay, they have to submit with ROC, which we may say that it again and again, when they are approaching for whenever they are raising investments, they have to submit the this many of pages, hundreds of pages to ROC. So it may be a hectic task for retail investors. I'm not talking about the manufacturers or else the wholesalers, but it may be retail investors, hectic task for them. So retail investors having limited access to financial knowledge as well as resources, okay, they may not be competent enough to understand the intricate details mentioned in the prospectus. Okay, so a solution to this problem is an abridged prospectus. So that is the reason why abridged prospectus came into existence. Why? Because retail investors may not have more knowledge regarding the financial aspects as well as the resources. So they may have a little bit limited access towards this. So a competent in order to file these competent details in the prospectus. Okay, so this abridged prospectus came into existence, which is nothing but the summary of a prospectus, just summary of a prospectus, even though the prospectus may have 500 pages, but the keen and important aspects will be filed, which is known as the summary of prospectus. Okay, important material is communicated, well informed material, important material is communicated, okay, to the ROC, okay, and the investors also. So according to section 2 subsection 1 of Companies Act 2013, it defines an abridged prospectus as a memorandum containing the salient features of an issue. Okay, so the features to be included in a abridged prospectus are to be provided by the SEBI. According to SEBI provisions only, abridged prospectus should be furnished. So section 33 of Act mandates for annexing an abridged prospectus along with form for application of purchase of securities. So an application will be given. In that application, according to the requirements of the SEBI, they have to complete. Okay, so and this provides that this requirement may be dispensed with where the form of application was issued for in connection with a bona fide invitation to a person to enter into an underwriting agreement with respect to such securities. Means, see here, abridged prospectus is given somewhat it enables the these persons, it enables the retailer persons. Okay, so but if at all this abridged prospectus is not considered when this retail investor, okay, has connection with an underwriting agreement. Okay, or else he went for in agreement with an underwriting company, means, okay, then this abridged prospectus will not apply in case of underwriting companies. Okay, underwriters means those are the third parties. Okay, the main for example, A is the company. Okay, so B will be the underwriting company, means these companies' shares will be issued by this company but not the company A. Directly company A will not issue the shares, only company B will issue on behalf of A. Okay, because of so many reasons. Okay, so now B company is treated as the underwriting company. So in this case, abridged prospectus is not considered. Okay, and another thing is in relation to securities which were not offered to the public. Okay, they are not offered, they have not went for public issue. Okay, for example, the same company, A company, okay, it doesn't went for public issue. Okay, then if whenever it has not went for public issue, in that case also abridged prospectus is not considered. Okay, so section 33 subsection 3 of the Act provides that if company fails to comply with the provisions of abridged prospectus as discussed, it shall be subjected to a penalty of up to 50,000 for every default. Okay, 50,000 will be the penalty amount. 50,000 will be the penalty amount. So abridged prospectus means it is related to retail investors who doesn't have that much knowledge regarding the financial aspects and the management. Okay, so and the resources as well. So in order to enable them, abridged prospectus came into existence. Okay, through company law, which will be according to the provisions of the SEBI rules. Okay, and this abridged prospectus will not be applicable to underwriting companies, and also whenever that particular company has not offered to the public, securities were not issued. So in those two cases, abridged prospectus will not be considered. Okay, now if we see about shelf prospectus, so what does shelf prospectus means? So if we see in this case, drafting a prospectus is a cumbersome process as it requires number of disclosures and information to be passed on to the investor, because prospectus means it contains full information which has to be known by the investor. Why? Because investor is investing his amount in the company. So a prospectus should be drafted in such a way that it has to disclose many number of things, okay, with detailed full information. So it may also be possible that a company makes multiple public offers in one financial year, okay. In one financial year, the company may go multiple times for public issues. For example, 2023, okay, or else 2024. In January, it had gone for public issue, okay. In January, in the month of January, it went for public issue, okay. So after 3 months, again the company needs some investment, okay. So for this purpose, again it want to raise its funds through public issue. So in the month of March, it again went for public issue, okay. And after 2 months, again in July, it went for public issue. In October, it went for public issue. So in this year only, many times it is going for public issue, raising of funds. So every time, whenever, we all know that prospectus means whenever the company is going for public issue, it should submit the prospectus to the ROC, okay. But here, if we see in this one financial year only, it is going to 4 to 5 times for public issue. So each and every time it has to submit with 500 pages of prospectus. So definitely it will be a cumbersome or else a difficult process, okay. So why? Because it has to disclose number of disclosures and information need to be passed to investor. So in such a case, it will become nearly impossible for the company to draft an entirely new prospectus every time. And it is also crucial to note that significant changes may take place in the financial status of the company. So to balance the interest of the company as well as that of investors, the law provides the concept of shelf prospectus, right? To safeguard the company, to safeguard the interest, to balance both the company and the investors, okay. So if we see about section 31 of Shelf Prospectus of Companies Act, it provides that shelf prospectus means a prospectus in respect of which the securities or class of securities included therein are issued for subscription in one or more issues over a certain period without the issue of a further prospectus. What does this mean? Means a company issues a shelf prospectus when it has to offer for subscription by the public more than one round of issue. Shelf prospect is a single prospectus that can hold good for multiple public offers. Means all companies, here an information memorandum is given by the company, okay, regarding this shelf prospectus, okay. So here which companies are treated as allowed to have a shelf prospectus means SEBI specified institutions are considered as shelf prospectus companies only, okay. So shelf prospect, they can issue shelf prospectus document, okay. So on what basis this SEBI means? It gives validity. SEBI gives validity for a prospectus, okay. So SEBI gives validity for a prospectus where a company is again going for public or issue, okay. So for that, for those companies, okay, the SEBI gives validity for a prospectus. So validity means maximum of 1 year, okay, maximum of 1 year. So 1 year, maximum of 1 year. It has validity for maximum of 1 year. Like for example, if we recharge, we will recharge our phone, no, for 3 months, 6 months. After completing of the recharge validity, we will again recharge our mobile. No, likewise shelf prospectus also. Okay, a document will be given, a shelf prospectus document will be given for 1 year. Okay, for this 1 year, if at all the company, for example in January the company went for public issue, okay, again it went for, at this time it will submit the prospectus. Okay, then again it is going for March, and in March also it is going for public issue. So in March, July, October, in this year from 2024 Jan to 2025 Jan till next year 12 months. Okay, there is no need to submit the prospectus. Okay, why? Because it is having shelf prospectus. So when a company is having shelf prospectus for 1 year, even though it is raising its funds through public issue multiple times, okay, it is not required to submit the prospectus. At first only it has to submit. Okay, then shelf prospectus will be issued by the SEBI. Okay, then for 1 year validity, even the company is raising again and again the funds also, so there will be a validity period. Okay, so for that 1 year, it may not it is not required for the companies to produce prospectus again and again. Okay, but what does it do means an information memorandum will be submitted. Okay, so information memorandum has to be filed by the company while filing a shelf prospectus. Okay, so what does this information prospectus contains means new charges created. Okay, if at all there are any new charges in information memorandum, what does it has means if at all there are any new charges created by the company, so those have to be mentioned, or else all the changes in financial positions, okay, in changes in the financial positions that have occurred after the first offer of securities or the previous offer of securities and before the succeeding offer of securities, anytime. Okay, whenever they are going for first offer. Okay, so the details regarding the financial position, okay, and other such any changes, okay, whatever changes are there, all those changes need to be prescribed in the information memorandum. Okay, so such an information memorandum must be filed with the registrar within the prescribed time period, which is nothing but 3 months. Okay, prescribed time will be the 3 months. They have to submit with registrar this information memorandum prior to the issue of the second or subsequent offer made under the shelf prospectus. Okay, so whenever again they are going for another subsequent offer, okay, second offer, while they are going for another offer, another public issue. Okay, so at that time before 3 months, okay, time period will be 3 months. Within that 3 months they have to give this information memorandum and again go for public issue. Okay, under shelf prospectus. Further, it is also the obligation of the company to inform an investor about the changes if they have been allowed the securities in advance before the adjustments. Okay, so this information need to be known to the investor. For example, new charges have been levied on the shares, so this has to be known. This has to be known to the investor. Okay, why? Because he is invested in the company, so he has to know. Okay, the investor has to know about the changes in the company. And why? Because based on such information, an investor has also given the right to withdraw their application, and they will be refunded their money within 15 days also. Okay, so this information has to be given to the investor, and investor may decide whether to invest in the continue in that company, or else in order to withdraw his application. Okay, and if at all his application, he withdraw the application, means within 15 days, okay, the money shall be refunded by the company. So this is about the shelf prospectus. Okay, next, if we see deemed prospectus, what does deemed prospectus? See, according to this, deemed prospectus means it provides that any document through which an offer for sale is made to the public shall be a deemed prospectus. Okay, offer for sale. Okay, offer for sale to public. Okay, so this is considered as deemed prospectus. Offer for sale means a notice, a circular, an advertisement, anything will be considered as offer for sale. Okay, so it is pertinent to note that the document has to be issued to the public and not a particular set of persons. Even if an advertisement is made in a newspaper regarding certain shares left for purchase by the company, it shall constitute a prospectus, as has been given according to the Companies Law Act. Okay, so why? Because in order to be able to make an informed decision regarding an investment, an investor must have access to all the information about the company before investing in it. So institutional investors must receive such information without much trouble. It is the retail investors whose interest might be compromised if such information is not provided in due course. So we can say that prospectus becomes most crucial document for any investor intending to invest in a company. Okay, so that is why that is the reason why company law mandates the filing of a prospectus every time before raising a public investment. Okay, so we can say that deemed prospectus means offer for sale is made to public. Okay, that is known as deemed prospectus. Okay, here they cannot left their some shares to their company. Okay, to company persons. If at all they want to do like that, means they have to mention in a prospectus. Okay, so this is about the deemed prospectus. And if we want to explain about in detail about deemed prospectus, means for example, here a company is there. Okay, a company. Okay, a company is not interested to follow the SEBI guidelines or else anything like it want to issue shares to public, but it does not want to directly involve with the public. So it went an agreement with the underwriting company or issuing house, which is considered as issuing house. Okay, so shares issuing or else issue agreement with issuing house or else underwriting company. So this issuing house or underwriting company, okay, it will shares, it offers shares. Issuing house offers shares to public. Okay, shares to public, and this with a document to public through a document known as deemed prospectus. Okay, so now those shares are not, even though those shares are issued by the issuing company, issuing house or else underwriting company, but not the company A. Okay, the shares will be deemed or else the shares will be considered as the company's A's only, but not the issuing company. So this is a deemed prospectus, even though the third party involved, even though the A company is not directly issued to public its securities. Okay, even though the issuing company or underwriting company issues the shares to public through a document called as deemed prospectus, the shares will be A's company's shares only, treated as, they will be treated as A's company's shares only. Okay, so if at all there is any manipulations or anything happened, means issuing house director will be liable for offer for sale. Okay, so for example, in deemed prospectus, within 6 months a company should be issued shares. Okay, within 6 months they have to issue the shares, this A company. Okay, so if at all it has not issued the shares, means this company directors will be liable. Okay, likewise, if at all the shares offered to public company, price not received by the A company. For example, this company has not received the prices after issuing the shares by the underwriting company. Okay, then the company has every right to go for tribunal on this underwriting company. Okay, the director will be liable for offer to sale also. Okay, so here deemed prospectus means we can say that any document through which an offer for sale is made to the public shall be deemed a prospectus. Okay, so this is about the deemed prospectus. These are the different types of prospectus under prospectus. So a clear explanation of each and everything has been given here about a red herring prospectus, abridged prospectus, shelf prospectus. Okay, and deemed prospectus finally. Okay, so if we see under this, what are the key aspects related to prospectus in company law? So what are the key aspects means here, first one is the content. Okay, content of the prospectus. So under content of prospectus, what contents are there in the prospectus? Okay, so what information is given in the prospectus? That is known as the contents of prospectus. As we know that prospectus is a legal document that a company issues to potential investors, providing with them with full information about company's business, financial conditions, management and securities offering for sale. And the main aim is, or the main purpose is, to assist potential investors in giving a detailed information to take decisions. Okay, whether to invest in the company or not. For that, these contents of prospectus are very, very important. So under contents of prospectus, if we see, first one is name and address of the company. Okay, so the name and address of the company, it should be given. Name and address of the company. Okay, memorandum of association, name and address of the company, where it is located, where it is going to be located, what is the name of the company, memorandum of association, which is nothing but the external which is associated with the external affairs of the organization, not within the internal aspects. Okay, means how its relation with bankers, government, okay, customers, suppliers, competitors, sorry. Okay, so all these relates to external matters, relates to the memorandum of association, investors, everything. And classification of shares means we have classification of shares like equity shares and preferential shares. Okay, so how the classification of shares has been done, what is the quantity, what is the price of equity shares, preferential shares, how many equity shares are issued, how many preferential shares has been issued. Likewise, different aspects has to be given detailed information. And name and address of the directors, who are the signing parties in the prospectus, how many directors are there, what are their names, addresses. Okay, likewise, and also the promoters of the company and underwriters. As I said before, underwriters are the third party, okay, other company. So if at all they are associated with other companies, or else who are the promoters of the companies, all detailed information has to be given. And time of opening of subscription list, whenever they are going to open the subscription for the shares. Okay, so what is the time? and what is the amount. Okay, so amount payable on application, how many will be allotted to each person, when will be the first call, when will be the second call. Okay, so calls. And likewise reserves and surpluses, what are the reserves and surpluses of the company, because the company's soundness depends upon the surplus and reserves of the company. So investor may decide if there are more reserves and surpluses in the company, means it is in a good position, financial position is good. So by seeing the reserves and surpluses also, the investor shows his interest to invest it or not. Okay, likewise amount of preliminary expenses. So preliminary expenses, we can say that promotional expenses. For example, if we want to issue the shares in the public, means for example we have to promote our company. Okay, so for promoting there will be initial cost, like which are considered as preliminary expenses. We have to go for advertisement. Okay, or else for example if we are selling some sachet free packets in order to promote our product, so those are all the preliminary expenses. So those are also has to be mentioned. And name and addresses of the auditors also. Okay, because auditors are the key persons, they will give the auditing report regarding the company's performance. So therefore their name and address is very important, because if there is any manipulation, we can legally go on auditors. Okay, so likewise voting rights at the meeting of the company. So shareholders has every right, because shareholders are the owners of the company. So therefore what are the rights, what are the responsibilities, what are the obligations of the shareholders, and whenever the meetings are going to be conducted, because for every quarterly one meeting should be held in every company. Okay, likewise 4 meetings should be conducted in annually. Okay, therefore in each time what are the rights, voting rights of the shareholders, those have to be mentioned specifically, because they have the shareholders are the persons who are the owners of the company, and they will elect the directors of the company and board of directors. Okay, so therefore report of auditors also has to be seen. Okay, so report of auditors are given by the auditors. The report may be the very positive reports will be given. Okay, so it shows the financial performance of the company. Okay, so depending upon these report of auditors also, or by seeing all the contents of this, an investor will decide to whether to invest in the company or not to invest in the company. So these are major aspects in the content of the prospectus. So if we go for the level of detail required depends upon the nature of the securities being offered and the regulatory requirements of the jurisdiction. So this is the contents of the prospectus. Okay, we can say finally that it is company's history, objectives, financial statements, risk factors, okay, details about the securities being offered, and information about the management team. So this is content of the prospectus. So if we see the approval and registration, okay, so approval and registration means in many jurisdictions the prospectus must be approved by the regulatory authorities before it can be issued to the public. Whenever they are going for a public issue, definitely they have to be approved by regulatory authorities called ROC and SEBI. Okay, without their authorization no company can go for public issue. Only after approval and registration of this prospectus only, okay, they can go for public issue. So the regulatory body ensures that the prospectus contains all the necessary information and it is not misleading. Okay, so after approval the prospectus is registered with the regulatory authority, right? So this is about the approval and registration of a company in about the prospectus. Okay, so if we see about the public offering, so what does public offering means? The prospectus is used in the context of a public offering of securities. Okay, so securities are nothing but the shares and debentures of the company. So a public offering involves making securities available for purchase by the general public. Public offering means we are going for public. Okay, we are offer for sale for public. Okay, so this is the contrast to private placement. Like private companies, they cannot go for public issue. Okay, and there in private company securities are offered to selected group of investors only. But here in public offering, there is no selected group of investors. Every person has right to go and purchase in this whenever there is public offering, like or else through notice, through circular, through advertisement. Okay, so it is considered as a prospectus to public. Okay, therefore after completion of public offering, invitation to subscribe for securities. Okay, why they are going for public offering means, okay, to purchase their securities. Okay, so invitation, they are giving invitation through prospectus. So the prospectus serves as an invitation to public to subscribe for or to purchase the securities offered by the company. So it is a legal requirement to provide a prospectus when offering securities to the public to ensure transparency. Okay, to ensure transparency and protection of investor. Okay, so this is known as invitation to subscribers, subscribe for securities. And liabilities for misstatement. Okay, misstatement, it means that the information provided in the prospectus must be accurate and not misleading. Okay, true fact informations, appropriate accurate information should be given to the investors, because they are investing their amount in the company. So definitely they have every right to know the true information, accurate information, which is not misleading. Okay, so if there are any material misstatements, for example any misinformation, misstatements or omissions in the prospectus that result in investor losses, okay, so the company and its officers may held legally liable. Okay, okay, in case of misstatement, company and its officers, okay, both are legally liable. Investors have a right to rely on the information disclosed in the prospectus. Okay, so therefore here in case of the losses, when they are liable, when company or the members of the company are liable, means whenever this misstatement has been led to the loss to the investor. Okay, this results in the loss to the investor. In that cases, investor can go for tribunal. Okay, then this company and members of the company are liable. Next, period of validity. Period of validity means here a prospectus is typically valid for a specific period, after which it may needed to be updated or reissued. So this ensures that investors have access to the most recent and relevant information when making investment decisions. See, if we see for example general prospectus, if prospectus, when a prospectus should be submitted means whenever they raise the funds, whenever a company raising the funds means it has to go for public issue. So public, whenever it is going for public issue, okay, prospectus should be submitted. Okay, prospectus should be submitted with ROC. Okay, and it should be according to the SEBI guidelines. Okay, so again whenever it is raising funds, again it has to go for public issue, again it has to submit prospectus. So again and again submitting the prospectus means again and again it is giving the updated information of its company. Okay, financial position, management, securities, each and everything. Or else if we see, as I said before, in shelf prospectus, okay, in that also validity period will be 1 year. So after 1 year again it has to submit the prospectus. Okay, so whenever there is a period of validity for this prospectus, it ensures investors, okay, having access, the investors will have access to the most relevant information and recent information when making investment decisions, right? So these are the key aspects related to the prospectus or the procedure in the prospectus. Okay, so what are the essentials, conditions of prospectus? What is required to be a prospectus? To fulfill a document of prospectus means, first of all we have to invite public. okay, then only we can go for prospectus. Okay, invitation to public, invitation by, these are needed. Okay, while we are going for prospectus means, okay, prospectus means we are inviting the public to purchase our shares, to purchase our securities. So therefore we have to invite the public. So this is essential. Next, invitation by the company. Without company we cannot invite the public. So there should be invitation by the company, then only public approaches to purchase our securities. Therefore invitation by the company is needed. Okay, likewise nature of document and particulars there. So nature of document and particulars means here how much of securities of the company are being allowed, what is the nature, equity shares, preferential shares, debentures, what is the percentage of the dividend, or else at par they are giving. Okay, so different details should be given in the document or else the prospectus. Okay, so that is the nature of document. So full details about the management they have to give, about the directors they have to submit in the document, and what are the securities, what are the kinds of securities, what is the percentage of dividend they are going to be given. Okay, how much shares are being given. Okay, number of shares, number of prices of the shares. Okay, so each and everything should be disclosed. Okay, any document should be disclosed with full information. So that is the nature of document and particulars, and this is also essential. And information regarding securities of the company. So specifically here they will ask the securities. So we all know securities are equity based and debt based. Okay, so a detailed information should be given. What are the assets, what are the liabilities, what is the rate of interest. Okay, if at all we have taken loans means regarding those liabilities, what is the rate of interest, or else debentures. Okay, so debentures, what is the percentage given to the debentures. So for preferential shares, for equity shares, the percentage of dividend will be given. Okay, so what is that percentage of dividend, or else what is the profit, how the profit is distributed. Okay, likewise if at all there are any bonds and warrants, okay, depending upon those, what is the percentage they are going to pay, or else they are going to pay. All the details regarding these securities. Okay, so basically equity shares, preferential shares, debentures, bonds, warrants, all these. So total assets and liabilities of the company will be known. So all these should be given in the prospectus. So these are the essential conditions to be filled for a document of prospectus. Next, if we see liability for misstatements, as I said before, in the liability misstatement. Okay, misstatement means giving misinformation, wrong information, or else not disclosing the full information. So if at all there is a misstatement means the company or the officers or the management of the company are liable. Investor has every right to take to sue on that company. Okay, so therefore what are the misstatements, what is the liability means. Liability means we can see civil liability and criminal liability. Okay, civil liability means company and persons authorizing the issue of such prospectus are liable for loss if at all due to this misinformation, misstatement, or else not disclosing the full information. If at all due to that reason, if at all the investor undergoes loss, okay, means the company is liable. The persons authorized to issue of prospectus are liable. Okay, so and when these company or the persons are liable means these conditions should be fulfilled. Means subscription to securities acting upon the misstatement. So whenever an investor subscribed, okay, to the securities, those securities should be under misstatement, okay, which the investors has purchased, those securities should undergo for misstatement. Then only these company and persons will be legally liable. And when another condition is loss or damages, if this investor got loss and damages by purchasing these securities means then company and persons are liable. And knowledge of defendant, okay, must be proved. Means the investors by knowingly okay, or unknowingly they have invested in the company. If at all the investor knows that the company is doing misstatement, if it is knowledge, if such information is known to the investor, but even though he purchased the shares or else the securities, means it is not considered, then the company will not be liable. But when the investor does not know anything about the misstatement or else about the disclosures of the information in the regarding the company, so this can be considered by the court. So knowledge of defendant must be proved by the plaintiff, and such misstatement must be material to the facts. Okay, so material to the facts means definitely which the securities has been purchased by the investors. With that information, if investor got losses, means that should be proved. That should be regarding misstatement only, regarding that material, that particular information only investor purchased, and that leads to the loss, means so this is also considered. So these are the conditions that an investor can sue on the company, or else the company and persons are liable for such loss. If we see criminal liability, okay, so in this, what are the remedies? Means here remedies include rescission of contract or damages for the non-disclosure of materials. He can investor can rescission of contract can be done, or else claim for damages, okay, for the non-disclosure of material facts. Okay, next, criminal liability means criminal liability has been provided under section 447 of the act. Okay, and here also all the directors authorizing the issue of the prospectus will be liable. Proposed directors also liable. The proposed directors are also will be in the prospectus. Okay, and promoter of the company, we all know promoter of the company is nothing but the initial person who started the company, established the company. Okay, likewise, and any expert involved in the issues, means experts are nothing but the C executives, or else like the chief financial officer, or else company secretary, CS, auditor. Okay, likewise, a expert of the company, they also will be liable. And for this, what will be the remedy? Means imprisonment of 6 months, imprisonment of 6 months, and more than 10 years also may be there. Okay, along with fine, okay, which shall not be less than the amount of damages suffered. Okay, so for example, a person has suffered 10,000 loss. Okay, so it will be 3 times, means 30,000 will be, okay, 30,000 damages should be paid by the company to this investor. Okay, this is the remedy. Okay, or else the company will pay damages to the investor. Okay, so if we see statement in lieu of prospectus. Okay, so what does statement in lieu of prospectus means? So when a public company is formed and chooses not to issue a prospectus, it is legally required to submit a statement in lieu of prospectus. Okay, so just understand, prospectus means a detailed information, a full information of the company is given or submitted in the form of a document to ROC. But statement in lieu of prospectus means where a company chooses not to issue prospectus. It doesn't want to issue prospectus. In such cases, this statement in lieu of prospectus should be submitted with ROC. Okay, so we can consider the statement in lieu of prospectus as a substitute prospectus or else substitute circular. Okay, so what does the statement of lieu of prospectus contains? Means it contains about the company and its offerings and must filed with ROC to ensure transparency and compliance. It is common in prospectus or statement in lieu of prospectus, giving information and at the same time filing with ROC is common in prospectus or statement in lieu of prospectus. Okay, so And here if we see, statement in lieu of prospectus means a statement instead of a prospectus issued by a public listed unlisted company. Okay, instead of a prospectus, unlisted company will issue this. It is a document prepared by public companies that do not issue a prospectus when they are formed. So where actually why we will give prospectus, why we will have to go for prospectus means whenever we want to raise the funds, we will go for public issue. So why to raise our funds? But here instead, state in lieu of prospectus means they are not going for public subscription. Okay, they arrange their amount privately within the company, maybe within the internal management or else from private persons. Okay, so in such case there is no need to submit prospectus, but they need to submit the statement in lieu of prospectus. Okay, so this is the basic difference between the prospectus and in lieu of prospectus. So what does contents of statement in lieu of prospectus contains? Means company name will be there. So these are the major information. This is the major information that will be given by the statement in lieu of prospectus. Okay, so they will give the major information like the company's name, okay, address and company's name, company's share capital. Okay, what is the share capital, what are the ordinary shares, and what is the value of each share. Okay, likewise description of planned activities and prospectus, name, address, roles and responsibilities of proposed or appointed directors of the company. Okay, their addresses, their name, their roles and responsibilities, who are the lawyers, appointed lawyers and company secretaries, because these are the key major persons who plays the key role in the company. So their information will be given, and rules for selecting and compensating these corporate representatives. So on what basis, okay, they are selecting these C executives or the experts in the company. Likewise, voting rights during company meetings. What are the rights? Voting rights are very, very important on the part of shareholders. So what are the rights given to them will be given in the statement in lieu of prospectus. And at the same time, quantity and value of shares. As I said before, in red herring prospectus, they hide, they will not give full information regarding the quantity and price, means how many shares are going to be issued and what is the price of their shares. But here quantity and value of shares and debentures intended to be issued. So the quantity should be mentioned, how many shares are to be issued, value of each share, and what is the percentage of dividend that is paid to the debentures. Okay, so debentures are nothing but the creditors of the company. Okay, and names, jobs and addresses of selling goods bought for offered for sale by the company. Okay, when if the company is selling the goods or else it offered for sale. Okay, so who are those persons, what are the names, jobs and addresses of those selling goods bought. Okay, and amount to be paid in cash. Okay, so amount paid in cash, stocks or bonds in real estate seller. So what is the cash, how many what is the stock of the company, bonds of the company, means each and every aspect which covers the assets and liabilities of the company should be furnished in the statement in lieu of prospectus. So this is about the statement in lieu of prospectus. So if we see provisions for statement in lieu of prospectus and section 70 of Companies Act, which deals with provisions of statement in lieu of prospectus. Okay, so a company with share capital that either doesn't issue a prospectus or has issued one but hasn't allocated any shares to the public must follow certain rules before allocating the shares and debentures. Okay, means statement in lieu of prospectus means which doesn't submitted the prospectus or else which doesn't issued the shares to the public, even though it issued the shares but shares are not been allocated. In this case also this statement in lieu of prospectus should be submitted. So at least 3 days before making the allotment, okay, the company must submit statement in lieu of prospectus to the ROC, okay, for registration process. 3 days, at least 3 days before making the allotment, because allotment should be made to each and every investor in the company. So on what basis allotment has been made, okay, so that should be given to the submitted to the ROC. So this statement should be signed by every person listed as a director, okay, those are the responsible persons, so they should sign on that particular document which is submitted in the ROC, okay. So those are the authorized agents, okay. And when a private company, in case of when a private company transforms into public company, in this case also it must provide to the registrar with a statement in lieu of prospectus, okay. So here if we see that directors should sign on it, and they should submit within 3 days before allotment. And other company means whenever a private company it wants to transfer into public company, in such case statement in lieu should be submitted with ROC. So this is a provision given in under section 70 of the Companies Act, okay. So whenever if there is a failure to comply with these rules, if at all they the company failed to comply with the rules of Companies Act, means fine will be there, fine of amount 1000 for the company, and every director is responsible, okay, because directors are the people who are elected by the shareholders in order to see the day-to-day activities of the company. They are responsible persons, okay. So if at all they do not comply with the SEBI rules and the registration of the Companies Act, 1000 for the company will be find them, okay. So if the statement in lieu of prospectus contains false information, okay, the person who authorized its submission can face imprisonment up to 2 years or fine up to 5,000, or both can be levied on that particular person, okay. When means false information, if they while submitting the statement in lieu of prospectus, if at all they have not revealed the full information, and if at all there is a misstatement, then the person who is authorized or else the person who submits that particular prospectus to the company, who will sign on that statement in lieu of prospectus and submit to the ROC, that person will be liable to 2 years and at the same time 5,000 also fine, or else both can be levied on that person, okay. So here if we see finally, statement in lieu of prospectus is a document issued by a public traded company which provides unlisted company, which provides essential information about the company's securities without the extensive detailed info found in a traditional prospectus. It is employed in specific situations where a regular prospectus cannot be used, such as when a company that is already trading in the market wishes to offer additional securities, right. So unlike prospectus, statement in lieu prospectus does not require prior approval from securities. Why? Because they are not going for public issue, okay. They are settling their amount, they are raising their funds within the management only, within the company only. So there is no need to get a prior approval from securities commission, okay. So they have to submit statement in lieu of prospectus. So this is about the prospectus, the contents of the prospectus, the types of the prospectus, and the statement in lieu of prospectus. And here we have to know about the liability also regarding the misstatement, like civil liability and criminal liability. So this is all about the prospectus.